What I've struggled with today is the fact that as a physician, and I'm a lawyer, I'm not a physician, so I've have gone to the Federal Register to try to read what has been written about this rule, and I'm focused on the non-directive counseling piece that I've struggled with, and you heard me ask those questions before. And that's what I cannot quite reconcile today from what all of the associations and what the organizations that we've all heard about, but yet I'm hearing from the top official who oversees the office that oversees these grants. And her testimony, both written and present today and backing up this rule, which is the Federal Register rule, 42 CFR Part 59, continues to talk about the fact that non-directive pregnancy counseling does provide and allow for providers to give lists of qualified comprehensive primary health care providers which may provide abortion services. And so I'm really struggling with the assertions that that will no longer be allowed under this rule. And I have such tremendous respect for the not client, I'm the lawyer, client, the physician-patient relationship, and yet why would a physician under this rule, where the rule allows and the Federal Register allows, and the top doc overseeing this said it is okay, and in fact it is permitted, why would they not be able to provide a list and to have a discussion about abortion when the 13-year-old came in with her mother? Why do you believe that when she came out very specifically and said that's not what we've written in the rule, that's not how the Federal Register is being interpreted, that's not what we're stating, that's not what she's testifying to under oath? Why do you believe those discussions cannot happen? Dr. Parrott? Whether you heard what she said, whether Absolutely. You've read her or not, I respect what you do. I respect what all of you do, and so I'm confused why everyone is not listening.
Sure.
To
Let
what
me
she
offer
said
some clarification. I think Ms. Coleman really spoke to it best when she really stressed the linkage between counseling and referral. There's something in the medical field called linkage to care. Okay. It means that you don't just give someone a piece of paper, say, good luck, I wish you well, be on your way. Particularly when we're talking about under-resourced communities. Being trapped in a cycle of poverty it preoccupies you with survival. So what that means is that even disconnecting services and moving them out of the same building is a barrier for people. It's a barrier for the communities that I take care of. So when we offer a list with no context, with no additional information, no realistic avenue to access those services because it is not tied to a referral, that means people cannot get the care that they need. That is not non-directive. That is not patient care. That's not how medicine works.
But would you not agree that a provider can have the discussion even under the rule and can talk about the pros and the cons, but as I read it, now I'm a lawyer, so I'm trying to read this rule literally and what the CFR literally says, but they can provide counseling and education, but the client has to take that active role in then deciding that information. And so why is that not, so that 13-year-old and her mother, a provider can answer questions, can say, here's the list of places that provide all sorts of services, including abortion, okay? According to this, they may provide in addition to comprehensive primary care. That is what is stated here. And that is what I just heard Dr. Foley testify to. Now, it is not in the same building. That is true. This rule does not allow it to be co-located. It does not allow that. But I do not see how the rule does not allow, and I think we have a fundamental disagreement on what I believe Dr. Foley said can happen and what the rule is stating can happen and what the community that you're representing is saying can happen. And with that, I yield back.